All right, next case up is Beaulieu versus Stevens. Counselor ready, good.
Please support. George Brew on behalf of Family Kia and Mr. Beaulieu, the appellants. After the jury returned its verdict finding that the accident in this case did not cause an injury to the plaintiff, Mr. Stevens below, the trial court granted a new trial, and the order for new trial is what's on appeal. The order itself basically deals with the testimony of one expert, and that was plaintiff's expert, Mr. Smith. In essence, the trial court perceived that it incorrectly and unfairly limited Mr. Smith's testimony in the rebuttal phase of the trial. However, after reviewing the record in detail, we pointed out that there was no evidence that Mr. Smith would have presented during the rebuttal phase that was not covered by 5 treating physicians below. In essence, since he was not a medical doctor, he could not reach any opinions, for instance, that the forces that were involved in the accident actually caused the plaintiff's injuries. He was more or less limited to testifying with regard to the forces involved, a reconstruction of the accident, and at best an opinion that the forces involved are the type that are consistent with a cervical injury. It's that last point that was covered by the 5 previous treating physicians. We believe that the trial court incorrectly perceived that Mr. Smith was going to testify as to other issues that he was not. His complete proffer is found within the record. If you look at the complete proffer, you'll see that there really wasn't anything that wasn't covered below. So we believe in essence that the trial court perceived that there was additional testimony and incorrectly believed that substantial prejudice resulted to the plaintiff by limiting that testimony during the rebuttal phase.
Well, would the trial judge have had the discretion to permit the reopening of the evidence?
Would he have had the discretion to permit? Yes, Your Honor, he would have had the discretion to permit the reopening. But his decision not to...
He had thought that he exercised his discretion improvidently, apparently.
Excuse me?
He thought that he erred. He thought that he abused his discretion in denying the request to reopen the evidence.
That's correct, Your Honor. He believed at that phase he did. And I think when he made that decision...
So what's our standard of review of all that? Is it an abuse of discretion, of abuse of discretion, of abuse of discretion? Or what is it?
I believe you have to look at the decision that he made when he passed upon the record and made the decision to grant a new trial. This was not a case
but
where...
he had the discretion at the outset, and then he had the discretion to review whether or not he abused his discretion, and he decided that he had abused his discretion, and as a result of that, he granted a new trial. So what do we decide now?
The analysis that he made in deciding whether he abused his discretion is open to review in this court as well. He can't do that in a vacuum.
But we don't review that de novo, right?
I believe in the fact that you can almost review it de novo for the following reason. This is not a manifest weight of the evidence type of issue or question. This is a question that is perfectly framed by the proffer that was presented, the evidentiary decision as to whether or not it was appropriate. In essence, the trial judge acted exactly like an appellate court when he passed on that issue. The issue is completely well framed, so we're not dealing with ambiguous issues of manifest weight of the evidence or unfair prejudice as a whole upon a jury of the weight of the entire trial. We're dealing with a very specific issue, and he in turn acted exactly and precisely in an appellate capacity when he reviewed his earlier decision. And this court, we believe, is completely within its authority in analyzing that decision, and it's in its review capacity when it analyzes that decision to pass upon the propriety of that decision to overturn the earlier decision. It cannot simply be done in a vacuum, but when the issues are framed succinctly by the proffer that was presented, and when the evidentiary issue to admit or exclude is that clear cut, it does become more of a legal issue. I'm not saying that there are no factual distinctions whatsoever that come into play, but it's almost purely a legal issue. And in that case, we believe that the review is more or less one of de novo. Going back to the underlying testimony itself, again, I won't belate the point, but a review of the proffer of Mr. Smith's testimony does indicate that At best, I believe, the only additional opinion he could have maybe rendered or was somehow precluded or interfered with rendering would be that this type of At that point, I think the appellee even raises the point that Dr. Boehm's opinion was somehow critical to their case in chief. The defense made a decision not to present that expert. They presented another expert. In essence, a review of the rebuttal testimony of Dr. Smith, a fair review of that testimony, I think demonstrates that there was no substantial right or unfair prejudice. We believe the trial court was simply incorrect in its perception of what was going to be introduced through Mr. Smith, and therefore we request that the court reinstate the jury's verdict and reverse the order granting new trial. I'll reserve the remainder of my time unless there's any questions.
I'm going to give you about 10 minutes if you need it, I think.
Thank you.
And let's hear from the other side.
May it please the Court, Your Honors. Jessie Harrell on behalf of the appellee and cross-appellant Michael Stevens. Both the appeal and the cross-appeal have the same focus here, and that's really that the point of a trial is to get at the truth. And that's the reason that the trial court granted a new trial in this case, because he recognized that by preventing the plaintiff from introducing biomechanical evidence, that there was a disconnect and that the jury wasn't able to hear the whole truth of what happened here. Now, yes, the medical doctors did testify that the plaintiff's injuries were consistent with a rear-end collision, but they could not and did not testify that the forces generated from this low-impact collision were sufficient to cause those injuries. All you had was the defense bringing in an accident reconstructionist who testified that the change in velocity was approximately 1.8, and then asked the jury to use its common sense that could not have injured anyone. And then the problem was there was no expert testimony to fill in that gap. Is a change in velocity of 1.8 sufficient? What about Mr. Smith's accident reconstruction testimony that it could have been higher at a change in velocity of 5 or 10? The jury just has no way of knowing what the accident reconstruction testimony, whether it was sufficient or not, without the biomechanical testimony explaining what forces do to the human body. And that's really where the error was, and why the trial court granted a new trial. But I also wanted to point out that his order is not limited to the testimony of Mr. Smith on the biomechanical testimony. If you look at the plaintiff's motion to reopen the case or to introduce in rebuttal, the plaintiff moved to introduce testimony of Dr. Boehm and of its own biomechanical engineer, Mr. Smith. excuse me. That was also present in the motion for new trial. And in the trial court order, the court didn't say that the plaintiff should have been allowed to call Mr. Smith as an biomechanical, to offer his biomechanical testimony. He didn't limit it to that. He just said that the plaintiff should have been allowed to introduce the biomechanical testimony he sought to present, which was both Dr. Boehm and Mr. Smith. So I just wanted to address that because I think that was a point that maybe wasn't clear in the briefs and why we raised that as to the harm in not being able to bring out the information in Dr. Boehm's proffer, because he did have biomechanical opinions that were relevant and that the plaintiff proffered and asked to bring in as well.
All right, explain to me factually how this got all screwed up.
Factually, the trial court wanted to get the trial done within a week's time. The defense represented on multiple occasions that they were going to call Dr. Boehm, and so in an effort to save time, the plaintiff offered to save, he had one expert that was both an accident reconstructionist and a biomechanical engineer. He offered to save that person to...
That would be Smith.
That would be Smith, yes. Save him to rebuttal to save time so that he wasn't calling him both on direct and in rebuttal. And the trial court specifically made that finding in its order that that was the purpose. The defense I haven't seen anything where they said they didn't make that representation and haven't challenged the finding that that was why the plaintiff did what it did. And then through no fault of their own, in fact, as it continues along, you see in the record, they're planning time. How long is Dr. Boehm going to take? They go on a brief recess, come back. Oh, we changed our mind. We're not going to call Dr. Boehm. And so the plaintiff was totally sandbagged by not being able to introduce Mr. Smith's testimony and rebuttal for the biomechanical forces, or to even be able to cross-examine Dr. Boehm as they had anticipated, because he testified that if the forces were higher than what the defense accident reconstructionist said, and there was no intervening injury, then all of the plaintiff's injuries were causally connected to this rear-end collision.
But the plaintiff says that they would have called the witness in their case in chief had it not been for the representation of the defense, right?
Absolutely, Your Honor. And that's why, and there's no question that this testimony was relevant, admissible. We're not here on an evidentiary standard where it's, at least in the main appeal, where probative value outweighs prejudice, anything like that. I mean, this was admissible evidence. The only reason it was excluded was because it was saved to rebuttal, and the plaintiff was surprised when there was no biomechanical testimony offered by the defense. And the trial court appropriately recognized post-trial that it should have allowed the plaintiff to reopen his case to present this testimony, and that justice wasn't served because the jury was denied this critical testimony. And really, that's the function of a trial, is to get at the truth, to make sure justice is served, and the trial court is in the best position to assess that and make that determination, which he did. It was certainly within his discretion, and it would be very hard. I think that you have the reasonable man standard as articulated by the Florida Supreme Court, that if reasonable men could disagree about the decision of the trial court, then the appellate court cannot reverse. I want to spend a little bit of time talking about our cross appeal, because even though we believe the court should affirm the new trial order, we would ask that it instruct the trial court on remand to allow the introduction of evidence of Lieutenant Scott's injuries. Now, Lieutenant Scott was the driver of the vehicle. Our client, Lieutenant Stevens, was the passenger. This evidence was directly relevant and probative, excuse me, I apologize, because it went to rebut the central defense in this case, which was that no person could be injured in a minor rear-end collision. I mean, that was the defense.
We're going to have like a trial within a trial. We're going to have a trial about the plaintiff, and then we're going to have a kind of a sub-trial about the passenger, where everybody's going to be able to call doctors to find out whether he was hurt too. Is that what we're going to do?
Well, it could be very limited. The plaintiff offered to make it...
Well, I'm sure the plaintiff would want to limit it, but then the defense has an opportunity to try to prove that he wasn't injured either, and before you know it, we've got a second trial here, right?
The alternative, Your Honor, is allowing the defense to paint this fiction, which is what they did, was that Lieutenant Scott was sitting in the passenger seat laughing and wasn't hurt. And when you allow the jury to infer, contrary to what evidence would show, that the only other person in the vehicle wasn't injured, that tends to support the defense theory. But it's just not true. And the plaintiff was prejudiced by not being able to put on the true state of the facts, especially when you have the defense arguing in closing that this is essentially a laughing matter. How could he have possibly been hurt by this accident? Well, it is possible because there's evidence that the other person riding in the vehicle suffered immediate neck pain.
So if the other person was not injured, could the defense have introduced that evidence?
Yes, I mean, that's essentially what they did here, was introduce evidence that he wasn't injured, but it was contrary to the state of the facts. So the jury was totally misled. And that's really our problem, and why, this evidence, they made this relevant by bringing up the fact that they made it even more relevant. We believe it was independently relevant because it rebuts the central theory of the defense, but by going into the fact that Lieutenant Scott was laughing and having this common sense defense that nobody could be injured, just look at the laughter and what happened here, they've painted it in a picture. Was there an objection to the testimony
about the laughter?
Well, there wasn't an objection because that was true, but there had been multiple...
Well, it was true, but it might not have been relevant, right? I mean, that's what you're arguing, is that it really wasn't relevant, right?
Well, it was relevant to their theory. I'm not saying it wasn't relevant. It was relevant to their theory that this was a low-impact collision and that someone couldn't have gotten hurt. It does tend to prove, under the definition of relevance, it does tend to prove the defense theory. But the problem is it's not a complete picture. Yes, he looked at Lieutenant Stevens, our client, who had his glasses askew and said, "What did you do to me?" and laughed at him. But he also grabbed his neck. He complained of neck pain immediately afterwards. He went through treatment as he continued to get worse, and he had a fusion. To allow the jury to think that they were just sitting there laughing at each other and nobody experienced any immediate pain is a fiction that totally misleads the jury about the forces present in this accident.
So the relevancy is substantially outweighed by the risk of unfair prejudice. Testimony about the laughing. It may be relevant, but it's outweighed by the danger of unfair prejudice, is what you're arguing.
If you don't complete the picture, our argument is not that the laughter shouldn't have been brought in, but that the plaintiff should have been allowed to complete the evidence before the jury as to what really happened and not allow the jury to infer that Lieutenant Scott also was not injured.
Well, it's hard to see where you draw the line there, counsel. You got 6 passengers in the car, and the plaintiff's claiming injuries, but the other 5 passengers may not have been injured. It sounds like we're going to try a case where we're going to be putting on all kinds of evidence about these other 5 passengers, which really degenerates the trial and prolongs it. Doesn't the trial judge have some discretion in that regard?
Well, he does have discretion, Your Honor. If you look at the original ruling that the trial court made, because if you'll recall, there was a trial that was scheduled to go forward in December. There was a dispute over whether Lieutenant Scott's testimony was going to come in. And at that time, the trial judge said, "Yes, plaintiff, I agree with you. This is absolutely relevant. We'll have some limited testimony so that it doesn't become a feature of the trial. But plaintiff, you can call Lieutenant Scott. You can call the canned deposition of Dr. Grimes. It's already been videotaped. Defendant, you can rely on your witness list from Lieutenant Scott's case because that was a separate lawsuit. All of those depositions had already been done." And so the trial court exercised its discretion at that point to limit it and not have it become a feature of the trial. It wasn't until, and that's the whole reason there was a continuance, because the defense said, "We're not ready to go forward. If we're going to consider Lieutenant Scott's injuries, we need to have a continuance." So we have a 2-month continuance. We go to restart the trial, And the trial court at that point changes course and says, well, you know what, we're not going to bring up Lieutenant Scott's injuries unless we need to rebut Dr. Boehm. Now, as we know, Dr. Boehm didn't testify, and so Lieutenant Scott's injuries didn't come in. But our trial counsel, argued repeatedly that the defense had opened the door by bringing in the laughter, and that there should have been, the trial court had the discretion to keep it confined and not make it a feature of the trial, but it's really analogous to collateral crimes evidence. If it tends to rebut a theory of the defense, then it should be permissible so long as it doesn't become a feature of the trial. If the court has no further questions, we would ask you to affirm the new trial order and instruct the trial court to allow evidence of Lieutenant Scott's injuries on the retrial.
Thank you, counsel.
Thank you.
I would like to start briefly with the last point with regard to Lieutenant Scott's laughing issue. The issue with regard to Lieutenant Scott laughing arose in the following context. Lieutenant Scott had taken the stand and testified, in essence, that he was knocked partially unconscious, that this was an extremely serious accident. And it was this testimony that was simply directly contradicted by his deposition testimony. In his deposition, he had earlier testified several months before, almost a year before, that in fact he had looked over right after the impact and laughed because the co-occupant's glasses were tilted funny, and he found that amusing. And he was strictly impeached on that point. So in essence, he came to trial and gave a completely different story than what he had told in deposition. And that's the only context in which the laughing issue had come into play. The absolute treating history of the co-occupant of this thing had been the subject of many depositions that had even been taken during the course of time when discovery was consolidated during both cases. And there was a dramatically different medical history on both occupants as to when they first initiated any complaints with regard to pain and what have you. And so the trial court certainly properly exercised its discretion and found that the door was not opened to the complete medical history of the co-occupant, especially in light of the fact that the appellee concedes that the medical history of the co-occupant in no way can be utilized to prove whether or not Mr. Stevens, the plaintiff below, was injured in this case. And in fact, the other doctors, I believe, there was some testimony from the other doctors even to that effect. So if it's not relevant to prove the plaintiff's injuries, it's certainly going far afield from bringing it in, which brings us really back up to the one main point, and that has to do with the testimony of a Dr. Boehm, who was one of the defense experts. The defense had two experts, one who did accident reconstruction, and Dr. Boehm, who in addition to being a medical doctor was also a biomechanical engineer. The trial court had in fact pre-trial warned that if Dr. Boehm testifies that there's a certain threshold at which nobody can get hurt, that we may allow the plaintiff at that time to bring in injuries or some proof that somebody else was injured in the accident. The defendants below certainly objected strenuously to the relevance and to that course of action, but it became irrelevant when Dr. Boehm was not called to testify at trial. And in fact, the trial judge himself said, well, I guess we don't have to deal with that issue at this time. But going back up to the biomechanical evidence and the order on appeal, the order granting new trials specifically, we certainly believe, states that the plaintiff was somehow prejudiced because they held back Mr. Smith's testimony for rebuttal purposes. That's what the order says. I think there's no other fair reading of the order. Now, if that's the case, when the defense below chose not to call Dr. Boehm, then all of this evidence about what Dr. Boehm may have said on behalf of the defendants becomes moot. It's irrelevant. The defendant's case in chief has nothing to do with the plaintiff's case in chief at that point.
Well, except to the extent that the order says that they relied on the representation of the defendant, that the defendant was going to call Dr. Boehm, right?
Without doubt. And we don't dispute that they relied in holding back, and the order is clear on this as well. Upon the belief that they were going to call Dr. Boehm during the case in chief, we're going to hold our expert for rebuttal. Mm-hmm. That was the decision that was made. The defense elects after review not to call Dr. Boehm. So and
then the fair thing to do in light of that is to allow them to reopen, to put on the doctor that they that they didn't call in reliance on what the defense was going to do, and the trial judge would have had the discretion to do that and didn't do it, right? Didn't allow it.
No, I don't believe that that's the case, and for the following reason. The proper thing to do is then allow the scope of whatever testimony. This is an issue of scope on the testimony of Mr. Smith, not as to whether or not testimony that was not heard. Certainly there's no purpose in rebutting testimony that never took place. Now, in this case, and what I believe what the court is asking, in essence, is what should have been then the scope of Mr. Smith's testimony. And that's what the trial judge lays out in the order granting new trial. He believes that the scope of Mr. Smith's testimony should have been broader. And for that and this is rebuttal, mind you. We're talking about the rebuttal phase of the trial. So, in other words, he's saying the scope of Mr. Smith's testimony should have been the same as if he was testifying during their case in chief. That's in essence what the judge, I believe, in the order granting new trial says very clearly. However, where the judge is incorrect in his perception is that when you look through the proffer of Mr. Smith's testimony, in its totality, you see that he did not miss any of his primary opinions. He got all of his evidence into the trial. And furthermore, the only possible limitation on his testimony was that this type of accident is consistent with cervical injuries. And that's it. He's not a medical doctor, and the appellee is correct. He's not a medical doctor, so he can't provide that testimony. The plaintiff never had that testimony in Mr. Smith, and it's not error in that they didn't get it out on rebuttal. Pure and simple. It's very clear in that sense. We believe it is, at least, that Mr. Smith was not unfairly limited for that reason. And it's the testimony of Mr. Smith.
Had the judge excluded the testimony on the basis that, or precluded reopening on the basis that the testimony that Dr. Smith was going to offer would be cumulative with what he already had testified to, then that may present a different issue on appeal. But here, the judge, the issue on appeal is whether the judge abused his discretion in denying, in granting the new trial based on his perceived error in not allowing the plaintiff to reopen, right?
That is a correct statement. However, he did not he abused his discretion in the sense that his perception that additional testimony was necessary was an error. And that's a decision this court can review just as he reviewed it below when he rendered his decision.
I understand your argument.
Okay. And so for that reason, to overturn the jury's verdict, you have to have a reason to do so. And that reason, not only the error, even whether it be error or not error in allowing it to come in, must also be substantially prejudicial to the other side. You must have a substantial effect on their rights. And in this case, we simply present that the trial judge was incorrect in his perception that there was a substantial prejudice involved. And for that reason, if he is incorrect, then he necessarily abused his discretion in overturning the jury's verdict.
All right.
We yield the remainder of our time if there's no questions. Thank you.
Thank you, counsel.
Thank you all.